Hi, good morning. This is Rajeshkumar. Today, we are going to analyze one problem question on frustration. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. Let's move on to the problem question. Alan, a law student, he bought a ticket to watch the Liverpool Football Club play, as he is a great fan of their star striker, Norman Conquest. A week before the match, Liverpool FC announces that Norman will not be playing in the game as he has been sold to a rival football club. Alan immediately rings rival Liverpool FC and explains that he wants his money back as the contract to buy a ticket is now frustrated. Liverpool FC refused to refund any money and tell Allen that his seat will be available for him. The night before the game, the football ground suffers a fire caused by lightning strike and the game is cancelled. Allen is especially disappointed as he has spent £100 on a specially made banner saying Norman Conquest, a Liverpool legend. Advise Allen about any claim he may have against the Liverpool FC. How, if at all, would your answer differ if the fire was caused by the Liverpool FC caretaker carelessly throwing a lit cigarette away, which set the light to accumulated rubbish he had failed to clear? Allen's situation involves several key legal concepts, particularly focusing on doctrine of frustration and anticipatory breach. The initial attempt to terminate the contract due to Norman Conquest transfer. Allen sought to terminate the contract upon learning that Norman Conquest, the star player, would not be playing. He claimed the contract had been frustrated. Let's say the frustration and anticipatory breach. The doctrine of frustration allows a contract to be discharged if an unforeseen event radically alter the obligation agreed upon, as explained in the Davies Contractors versus Farham UDC case. However, for frustration to apply, the event must fundamentally change the nature of the contract, not just cause disappointment or inconvenience as highlighted in Krull versus Henry case in 1903. Non-frustration. The key issue is whether the absence of Norman conquest frustrates the contract. The ticket contract was for the seat to a football match, not specifically to watch a particular player. In Herne Bay Steamboat versus Houghton in 1903, it was held that a contract was not frustrated when part of the event was cancelled, but the main service, a boat trip, was still possible. Similarly, an Allen's ticket remains valid to watch Liverpool FC play, meaning the contract is not frustrated simply because one player won't participate. What is the anticipatory breach? Allen attempts to terminate the contract due to Norman's absence may be seen as an anticipatory breach given that no frustrating event had occurred. Liverpool FC refusal to cancel the contract aligned with the principle of White and Carter Council Limited versus McGrath in 1962, which permits a party to affirm the contract and insist on performance despite the other party's attempt to repudiate. In other words, Allen initially claimed frustration due to absence of Liverpool star player Norman, which is reminiscent of Krull versus Henry case in 1903. In that case, the contract was frustrated due to the cancellation of the coronation procession, as it formed the foundation of the contract. However, in Allen's case, the frustration is unlikely to apply since Liverpool FC performance under the contract, the provision of match experience, does not explicitly depend on Norman's participation. The courts generally find the frustration in cases where an essential part of the contract purpose become impossible to fulfill, not merely because one aspect, like the attendance of a particular prayer, is missing. Consequently, Allen's attempt to cancel the contract could be viewed as an anticipatory breach following the White and Carter Council versus McGraher in 1962. The Liverpool FC was within its rights to refuse the breach and hold Allen to his obligations, and maintaining that the seat would remain available for him. Let's move on to the second issue, the frustration due to the fire. The fire at the stadium caused by lightning prevented the game from being held. This could potentially frustrate the contract. A doctrine of frustration, a fire qualifies as a supervening event that makes the performance impossible. Under Taylor versus Caldwell in 1863, the where a fire destroyed a music hall, it was held that the contract was frustrated because the subject matter no longer existed. The Allen's ticket was for a specific match that can no longer occur due to the destruction caused by the fire. Thus, the contract is frustrated by this event. A law reform, the Frustrated Contracts Act 1943. Under the Section 12 of this Act, Allen can reclaim the ticket price, while the Liverpool FC might have incurred expenses preparing for the match. The court has a discretion to decide whether they can deduct these expenses from the refund. In other words, the day before the match, a lightning strike caused a fire, rendering the stadium unusable. Here, the frustration is likely applicable as unforeseen fire made it impossible to fulfill the contract, releasing both the parties from further obligations. The basis of this analysis stems from a Taylor versus Caldwell case in 1863, where a fire destroyed a music hall, discharging the contract due to the frustration since the venue's existence was essential for performance. Another law reform frustration contract act 1943 section 1-2 would allow Allen to recover any advance payment. Although Liverpool FC had initially refused his refund request regarding the Norman's unavailability, the fire provides a legitimate frustration event justifying a full refund under the statutory law. Let's move on to the third issue, the alternative issue, the frustration due to the careless conduct. If the fire was caused by the negligence of the Liverpool FC caretaker throwing a lit cigarette, the self-induced frustration. The frustration cannot be claimed if the frustrating event was caused by the fault of one of the parties, as per the Maritime National Fish Limited versus the Ocean Travelers Limited in 1935. In this case, if the fire was the result of the Liverpool's FC's negligence, the doctrine of frustration would not apply. Liverpool FC would be in the breach of the contract because the fire was self induced. Allen would have a claim for the breach of contract and could claim damages beyond just the ticket refund. Allen could potentially claim damages for his financial losses, including the £100 spent on the banner, since the Liverpool FC negligent action led to the game's cancellation. In other words, if the fire had been caused by negligence, such as carelessly discarded cigarette by the club's caretaker, it would be a case of self-induced frustration. Per Maritime, National Fish Limited versus Ocean Travelers Limited 1935, the frustration cannot apply when the event was within the one party's control. Now, Liverpool FC would be liable for the breach, and Allen could claim damages, including the non-pecuniary loss for the disappointment and the expense of the custom-made banner. Let's conclude. The frustration applied to the lightning strike, allowing Allen a refund under the 1943 Act. Allen's attempt to terminate the contract is unjustified. The contract was not frustrated By Norman's transfer, and Allen's action could amount to an anticipatory breach. This is for the initial claim. A claim for the fire caused by lightning, the contract is likely frustrated, and Allen can claim a refund under the Section 1(2) of the law and the reform of the Frustrated Contract Act 1943. What about the claim after the fire caused by negligence? The frustration would not apply due to the Liverpool FC fault, and Allen could claim damages for the breach of the contract. Thank you.